The date? Yes, he was arrested by Anti-Terror Police Unit. That is on 27th May 2024. On the same allegations, Your Honor.
One H, that the accused person should be released on bond or cash bail. Then Article 49. Opportunity to go through the same. My colleagues are before the brother in court number 11. They are taking a ruling. I would very humbly pray that they pass the application.
Yeah, Your Honor. Good afternoon. That such a kind of application has been made before you. Now going to 3 o'clock, and we don't know when they will finish. Council will be holding a brief because it doesn't require anything. It's an application, so that once the court returns to make a ruling at 4, will be part of the ruling being delivered. It doesn't require any rocket science. A person is supposed to prosecute his application before. That is ingenious. And I wish that such a kind of...
Yes, Your Honor, like I indicated earlier, I have very limited instructions in this matter. And I've only been handed this application as I was working in. I actually have only one copy. I do not know what it entails. And Your Honor, there is no simple application before court. Your Honor, we cannot proceed.
My learned senior, Mr. Ivan. Your Honor, the purpose of this application, there is a prosecuting person before you, who is the IO. The only thing counsel is needed to do is to guide the applicant in prosecution of his application. Your Honor, if the court were to grant him his request, and we allow counsel who is appearing before your brother to appear before you, it will still appear that the officer who is the applicant in this matter will be the person prosecuting. And the learned counsel who will be appearing will only be guiding him on prosecution of this application. These are delaying tactics, Your Honor. There is a supporting affidavit in this application. This application, Your Honor, is straightforward application. Your Honor, you've indicated you're retiring to give a ruling at 4. We'd wish that when you retire to do your ruling, you will be handling both two applications as we wait for the ruling at that time.
Very well, most obliged. So that the accused was arrested on 7th of June 2024 for the offence of obtaining goods contrary to section 313 of the Penal Code, which was reported under OB number 2602 of 2024. In his examination, Dr. Stephen Kegoro indicated that he arrested the accused today and he needed time to complete his investigations. He further informed the court that he had written a letter to World Food Program and was awaiting a response. On cross-examination by Mr. Musweti, he indicated that he was not the IO in the other matters criminal case number 411 of 2024 and 414 of 2024, and was not aware whether the accused person in the said matters were out on bond. On further cross-examination by Mr. Ondigi, he indicated that he had been looking for the accused person for about 1 week. The respondent's counsel submitted that in the two matters, E414 and E411 of 2024, investigations were done and the respondent was exonerated, and the police were out to intimidate and harass the respondent. He informed the court that the respondent was arrested by the anti-terror police on 27th of May 2024, and no charges were preferred, and he was released on 29th of May 2024. It was his submission that the application before court was an afterthought and the offence is not serious and the respondent was not a flight risk. He further indicated that the respondent was unwell and required urgent medical attention. It's not in dispute that bail is a constitutional right as stated in Article 49 on H of the Constitution. While accepting the text of Article 49 1F of the Constitution may in certain circumstances and context comprehend a situation where a person is presented before a court without being formally charged and is informed of the reasons for his continued detention through the state's application through the state's application. The state also must satisfy a double test. Number one, the first is the state must prove to the court that it is acting in a good faith and continued detention of the individual without a charge being preferred, whether provision or otherwise, is inevitable due to exceptional circumstances. B, the state must demonstrate that continued detention of the individual without a charge is the least restrictive action it can take in balancing the quadruple test present in a potential criminal trial, which is the rights of the arrested individual, public interest, order, and security. Order and security, and the need to preserve the integrity of the administration of justice and the interest of the victims of crime. In other words, the state must demonstrate compelling reasons to deny the pre-charge bail. The IO, while being cross-examined, indicated that he needed time since he arrested the respondent this morning. The IO has not demonstrated whether the respondent is likely to interfere with the witnesses. In a nutshell, I find that the state has not provided compelling reasons to have the respondent detained for 14 days. Therefore, I hereby grant the respondent bond in the following terms. Number one, bond of 500,000 plus one surety of a similar amount. The alternative, cash bail of Kenya shillings 200,000. The respondent to report at Kamukunji police station to the investigating officer on a weekly basis on Mondays until the investigations are completed. Those are the orders of the court.
Yes, we have an application before you dated the 7th of June 2024, seeking custodial orders S so that it is respondents. The application seeks custodial orders against each of the respondents for 14 days. You know, every arrested person has a right to appear before court and to be released by dint of Article 49, or to be informed of reasons for continued detention. Our intention in the supporting affidavit to the application is to inform the court, or rather inform each of the respondents through the court, of the reasons why we are seeking their continued detention, and which is to continue and complete investigations, the nature of which will be highlighted by my colleagues, into a suspected or a number of suspected offenses, including stealing from a locked motor vehicle, contrary to Section 279G of the Penal Code, Cap 63 laws of Kenya. Conspiracy to commit a felony, contrary to Section 293 of the same statute, 393, sorry. And handling of stolen property, contrary to Section 322, subsections 1 and 2 of the statute, the Penal Code. And Your Honor, that if this court is persuaded on the basis of the affidavit sworn by Inspector Omondi, we would be pleading with the court so as not to beat the intention and purpose of the investigations, to hold them just for another 2 weeks, by which time we contemplate the investigations team shall have completed the investigations, and upon which we can come back to court to make appropriate applications, either for denial of bail or for review of our application. But Your Honor, while bail is a constitutional right, by dint of Article 49(1)H, the same is not absolute, and that where sufficient reasons are given, which we propose we have given you through the application and the affidavit, the court has justification to limit the right to bail in accordance with Article 24 of the Constitution. Like I've indicated, my colleagues will talk to you about the fact that it's noteworthy from the onset that the first to fourth respondents are police officers Act number 11A of 2011. If I got that right, yes. And such, it is a matter of common sense, being police officers, that the propensity and likelihood of interference with investigations is high. You and I deliberately use common sense. Further, that other than the high likelihood of interference with investigations, the first to fourth respondents, being police officers, and their two co-suspects, are likely to interfere with prospective witnesses. Allow me at this juncture to invite my colleagues. Thank you.
Investigation was commenced pursuant to a report which had been made Mihango Police Station by the OB 29/4 of 6/2024. You will note that the place of arrest of all the respondents in this matter is at the Kapsaret Police Station public parking. That is captured in paragraph 10 of the affidavit. Upon arrest of the same respondents who are before you, a search was conducted as enumerated in paragraph 11. And that search led to the suspicion that all the respondents had been involved in the offense which was reported at Mihango Police Station. Of a sum of money as enumerated in paragraph 11, and it was noted that the first to the fourth respondents, who are police officers who are not on official duty and had not booked the fifth and the sixth accused person in the occurrence book at Kapsaret. Your Honor, I now move to the compelling reasons as to why the state has...
You're aware?
I can't recite it. Okay. Let them proceed.
Your Honor, I'm informing the court of the compelling reasons as it makes it very likely that they will interfere with witnesses. Your Honor, the skills of the first to the fourth are not everyday person skills. They know how investigations are conducted. They know how to locate suspects and witnesses. And thus, having regards to those skills, the state's apprehension as indicated in paragraph 11 is a compelling reason as to why they should be denied bail or bond. Your Honor, as to the fifth and sixth respondents in the matter, a compelling reason is enumerated in paragraph number 12 of the affidavit. That they have no place of abode, no fixed abode, Your Honor. Their place was of arrest is Kapsaret Police Station, not in their homes. They have not given the IO an indication as to where they reside. And if the court was to grant them bail or bond, the IO is apprehensive that we will not know where to get them. And that, Your Honor, also goes to the fact that all of them were arrested together. So there is a likelihood of interference of witnesses also by the 5th and the 6th.
You are already married.
Were arrested on 6th June 2024. And were placed in custody by OB number 5 of June, OB number 5 of 6th June 2024 at 04:14 hours.
Where did you book them? Which police station?
Your Honor, respondent number 1 to 4 were booked at Kayole Police Station by the OB that I've just indicated, while respondent numbers 5 to 6 were booked at Troy Police Station.
Where were they arrested? The place in particular?
Your Honor,
All of them.
the 6 respondents were arrested at Kasarani Police Station at the public parking yard.
What was the time when they were arrested by you? Do you have any?
Your Honor,
What was the time?
the decision to arrest the suspects were arrived at around slightly past midnight.
Mr. Omondi, when did you take possession, or when did you arrest the first, the 8th, the timing, as per your signals to your bosses? If you don't know, we can show you where it is.
Your Honor,
Yeah, 6.
Your Honor, I will repeat again. The decision to arrest the 6 suspects were arrived at some minutes past midnight.
On which date?
6th June 2024.
Fine. Let me put it this way. When did you meet them? At what time, before you made a decision to arrest them, at what time did you meet them? At what time did you meet them?
Investigations which are ongoing. If we go outside this affidavit, we risk compromising our investigations. So kindly, if counsel could point us, as he asked questions, I'm now asking you about paragraph 8. That would help us. You cannot widen it.
Counsel, you did indicate to the court that they were arrested. They met them at
24 minutes past midnight, and were placed in custody after 4 a.m.
Mr. Mon, if I put it to you that the accused person have been in your custody for almost 48 hours, what do you intend to tell the court before they are arraigned in court? Confirm equally when Dominic.
Because when they were arrested, we conducted search on all the 6 suspects, and we made recoveries of money, that we believed to the stolen money that was stolen from the complainant.
What informed your belief?
That you are under arrest, whether in a toilet, on the street, or anywhere. It is presumed that you are under arrest and time starts running. The application before you, the Honor, has been brought in bad faith. It is an abuse of authority and misuse of judicial authority. The accused persons before you, the first, second to the fourth, are police officers who were on duty on that particular day and arrested the fourth to the fifth accused persons. Sorry, fifth and sixth accused persons, and took them to Kapsaret police station, where they were met by the team who arrested all of them. From that particular time, Your Honor, they were moved from one police station to another before they were booked as now being told in the application and affidavits. The prosecution has not indicated to the court, one, the reasons, compelling reasons why the first, second, third to the fourth accused persons could not be released on bond. The first to the fourth accused person are police officers, and they have affixed their bond. They are equally, the application belatedly brought before the court was supposed to sanitize that delay and the violation of the fundamental rights of the accused persons in general, and frustrating them. Your Honor, the first to the fourth accused persons will not interfere with any investigations being conducted, to be fair, by the prosecution. They are willing and ready, if this court listens to our position, that they are ready to attend for investigations at the DCI's office when required, or someone who can produce them at the station. Also, Your Honor, it has been indicated that
3 p.m. The respondents to be
Your Honor, on the issue of the court conduct on the issue of custody.
the application, you can see at just a minute. I can see
There are two police stations.
that Kawala police station, the 5th and 6th, to be detained at the Royal police station.
Much better.
May I request, Your Honor, before you